Hello, this is Matt on the Moon Family Sedan channel. Here's a headline from you today. Ripple v. SEC. Crypto lawyer makes startling prediction as case resolution nears. Now, I'll tell you right here at the outset of this video, what this particular attorney is citing makes a ton of sense, and I'm pretty well just about 100% in line with the thinking on this. Now, of course, I'm not an attorney. I just play one on YouTube. But look, if somebody has a logical, compelling case, it's going to strike me, even if I'm not some sort of professional on whatever the topic at hand is. And I've heard professional opinions from all sorts of attorneys, as I'm sure many of you have as well, and then we just use our own mental faculties to figure out what makes sense. That's kind of how life works in general. And I do think that this makes a ton of sense. And if it goes the way this attorney thinks it's likely to go, it's actually ultimately going to be really good for XRP holders. It's just, to what degree are we going to get clarity specifically for XRP, the asset itself? But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. And so I'm not going to read the article. I'm just going to go straight to the source. What I'm going to share with you here is what prompted the article, so I want to go through what he says and share some thoughts along the way. But it comes from attorney Jesse Hines, who has been opining on the SEC v. Ripple case for over 2 years at this point. And here's what he had to say. As we get closer to the resolution of the Ripple case, I'm going to throw down my original thoughts from years ago so people can tell me how unreasonably wrong I am when the case is decided. Let me know your thoughts. Early day sales of XRP will be found to have violated securities laws. Now, folks, let's pause and note, that would be a technical loss for Ripple. But then Attorney Hines also says, this will set a precedent that the SEC will use to go after many other companies. Essentially, if you sell something for fundraising, then you have created an investment contract. So I don't pretend to know exactly how this is going to come down. I don't know for sure if Judge Torres is going to decide that Ripple did engage in some sort of illegal, unregistered securities transactions with any specific XRP transactions. But I've been warning for quite some time that this is completely plausible. Ripple could have a technical lose here, which, by the way, would really grind my gears all up in this bitch. The reason being is, the way that things are supposed to work, certainly in an ideal world, is that if Ripple engaged in illegal transactions, then the SEC would cite those specific illegal transactions, and then the judge would rule on that. Instead, what the SEC did was they said, every single transaction forever at any point in the universe, past, present, future, all of it represents the efforts of Ripple. It's the embodiment theory. So XRP it's the embodiment of representing all of those efforts from Ripple, but without specifically claiming that Ripple itself is the common enterprise. Although they did previously, they changed their story so many times. They did initially claim Ripple to be the common enterprise, a prong of the Howey test, and now they've shifted it. They're going with this whole embodiment theory thing. So yes, Judge Torres absolutely still could come out and say, well, here's all of the evidence that's in front of me that came out in discovery. Even though the SEC didn't cite specific transactions, the judge could still say, okay, but I'm seeing this piece of evidence here. That looks illegal to me. Therefore, Ripple, you are in the wrong there. There's going to be some sort of consequence as a result of that. Now, that would be a technical loss on that point, but that's not something that would necessarily be devastating for XRP holders. But let's get a little bit further into Attorney Hines' thoughts on this, and we'll talk more about that. But we'll be breaking into the concept, obviously, of what matters to XRP holders, which is secondary market transactions. What about the damn clarity on that? And so Attorney Hines says, however, I do believe that the court will determine that Ripple is no longer violating securities laws in how they are currently doing sales. With that said, the biggest question mark is whether the court decides to tackle the question of whether XRP itself is a security and how to deal with the early day sales being securities. My fear is they won't actually decide on this. So I'll pause to note, that's a very real concern. Now, I don't really share a high level of concern. It sounds like Attorney Hines has a bigger level of fear on that than I do, but it's still a legit fear. A case in point here, if you look back to the library case, when there was the ruling which came out, I guess it was the beginning part of November, if memory serves, the SEC defeated library, and there wasn't any talk at that point in time about whether the asset itself was a security. And actually, on that specific topic, there still hasn't been from the court. So no clarity surrounding the asset itself. Now then, earlier this year, this was the end part of January, there was the remedies portion of that library case. So library already been defeated, but the judge did say some things that should help secondary market participants. A lot. And now technically, mind you, we're still waiting to see the final remedies portion ruling from the judge, but he articulated what he's going to do directionally. And what he said that he's going to do in a nutshell is make it clear that any secondary market transactions are not part of his ruling. So, and Judge, by the way, Attorney John Deaton was at that because he was amicus certainly for the remedies portion of the library trial, and so he was pushing for the judge to claim that the asset itself isn't a security. But the judge said something along the lines of, "Well, when it comes to this stuff, I'm a minimalist. If it's not necessary to say something like that." But we can still protect secondary market transactions. That's what I want to do. That's what the judge articulated at that point in time. So that's a real fear. You could have, is cited by, this is what Attorney Hines is getting at here. You could have Judge Torres in the SEC v. Ripple case just choose to not address that in the final ruling. And then if Ripple loses in some capacity, then you get to the remedies portion here. And then maybe she brings it up there if she does what the judge did in the library case. Now, he says that he's got a notable fear of this. I actually don't. I do not share that fear. I mean, I recognize totally that could happen, and that would be really regrettable. But if you look at how this judge has been behaving in this case and the way that she's been approaching things, just as an outside observer, just seeing her encourage and accept all of the amicus briefs. There were initially 17 request to file amicus briefs filed. I think the final number ended up being 15, if memory serves anyway. And she didn't deny anyone. And now that was also, thankfully, almost all in favor of Ripple. As spent a lot of time covering all those over the, months and months that they were getting dropped. But, I just, given that is the case, and just the openness, that I'm getting this vibe of openness. And I think that she understands, especially with John Deaton representing over 75,000 XRP holders, I think she gets the idea that whatever she rules here is going to be consequential on a global scale. And it is not too much to say that. It's going to impact global markets surrounding crypto and blockchain technology and businesses building on top of various blockchains. For sure. It's going to change all sorts of stuff one way or another. And I think she is going to be, my suspicion is that she'll be bold enough to acknowledge that and take that responsibility that she has head on and address it in a way that wasn't addressed in the library case. That's my suspicion. So I'm not saying I don't have any concern. I do have some concern, but it sounds like the way Attorney Hines worded his concern is that perhaps he might have greater concern than I have. For me, it's just like a little bit. But and that's what, and it is important though. Like, it's one of the most important things we could have coming out of this case, especially if Ripple loses, is okay, what does that mean for all the other transactions? That's of the utmost importance. If the judge comes out and says, Ripple, you broke the law here, ABC 1, 2, 3 times, whatever it is, fine. If that's what she finds, fine. But if she does that and doesn't make sure that there's clarity for secondary markets, when she knows just how consequential that decision is, that would be disgusting. And I don't think she's probable to do that. Now, she does, we'll cross that bridge when we get there. Anyway, Attorney Hines continues. However, the SEC has really been forcing this issue with their recent claims, so the court may feel compelled to make this decision. To be honest, if the court does make this decision, I am grateful that the SEC took this silly argument, because otherwise they wouldn't have. If the court does opine on the status of XRP going forward, which I am about 50-50 on whether they will or won't, the only logical conclusion is that XRP itself cannot be an investment contract. It just doesn't make sense. Okay, so let's pause and note. Obviously, I think we're all going to agree 100% on that, the part of XRP itself not being an investment contract. There's no shortage of case law going back 76 years indicating just that. So I don't think any of us listening here are doubting that. But when he's noting that it's a 50-50 chance that, that's going to be, approached by the court or not, well, again, let's make clear there are two separate things going on. Is the asset itself a security? And then separately, what about secondary market transactions? Now, I don't find it. I know that's what the judge in the library case, like I just said a minute ago, he kept those things separate. He said he wanted to be a minimalist. I find it perfectly reasonable to talk about both of those. Like, if secondary market transactions are not, if secondary market transactions are do not represent some sort of illegal activity there, well, the only way that could be true is if the asset itself is not a security. So why not be slightly bolder and address both? So in terms of whether or not Judge Torres is going to word it like that, I'm kind of up in the air too. But in terms of addressing secondary markets with the understanding that, of course, if secondary market transactions are not illegal transactions, then the asset itself cannot be a security. Because if the asset itself is the security, then every transaction would be illegal. So it technically, you could argue it gets to the same result, and that's what the judge in the library case was going for. I'm just looking for a little bit more boldness. So if you're asking, is there a 50-50 chance of that boldness? Maybe I'd agree with Hines on that more or less. In terms of whether or not we're going to get that clarity anyway, just because the judge approaches us and notes that secondary market transactions in the ruling, notes that those aren't illegal transactions, I much higher confidence than that, 80-90%, I don't know, way higher. And I think that we're going to get it, not in a remedies portion if Ripple loses, but I think we're going to get that clarity in a likelihood when the news drops, when the judge makes her final determination. And it doesn't mean that there couldn't be other things that actually have to go to a jury trial, by the way. That still could happen. That could definitely happen here. And Ripple could have to pay some sort of fine. But then for them to be enjoined from facilitating any XRP transactions in the future, is that what's probable? I doubt it. I mean, XRP switching from, selling XRP programmatically as well as for ODL, and then cutting off the programmatic sales and switching to just ODL years ago. Those transactions, even the ODL ones? Like, come on. And I think that is likely to be parsed out in this final determination from Judge Torres. And then Attorney Hines also says, I think the fair notice defense will only come into play if there is some odd determination that XRP, the asset, is an investment contract. Then Ripple has a very valid defense that there was no fair notice to this. But this really only helps Ripple and not users. But once again, I just can't see a court determining that XRP, the asset, is a security. Now that I firmly agree with. I do not think Judge Torres is going to find the asset is. That would be mind-blowing. And then I'd just be like, okay, how soon can we get this to the Supreme Court? And I know that you'd have an appellate court in between, but still. Like, however far we have to take this damn thing. It's ridiculous. And yeah, hopefully the fair notice defense stuff never comes up, because that does mean something has gone horrifically wrong, and it's not something that's going to help XRP users. So Attorney Hines is certainly right on that as well. Let me know what you think in the comment section below. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.